You guys are great. Thanks, Ngaya. Thanks, Watermelon. Let's give Ngaya and Watermelon a big round of applause. We try to keep it fresh and funky always. Speaking of fresh and funky, our next panel is, in every respective area where cannabis legalization is going on, whether it's under medical or recreational auspices, you have these gatekeepers, these oracles. These certain individuals that have been there for a long, long time and in this battle for a long, long time. Because before this became an issue of economics, it was an issue of just pure justice. Okay? And I mean, it's so important to understand that when we're there's how do I say this? I'm sorry, I never prepare any notes, by the way. But obviously you can tell. There's oracles, there's gatekeepers, and these gatekeepers are what we go to as the foundation from where everything springs from. And there's a certain amount of lawyers can be real shysters, okay? But in every, that's what I was trying to say. But in every respective area where there is the legalization and recreational things going on, there's always a few lawyers that are hardy activists. There's always a few lawyers that actually lobby against their own interests in terms of making money. And that is by reducing and ending criminal penalties towards cannabis. You know, nobody likes to see injustices if they make money off it. The only person who likes to see that are DAs. I don't know what you call those in Canada. Crown counsel. And I'm sure they're dicks. Okay.
They're wonderful people.
I said that. Those are my words. And with that, I'm going to give it up to Mr. Kirk Tousaw. We have an extremely powerful panel of three of the top advocates in Canada. I'm going to introduce Kirk Tousaw here. He is the man. If it wasn't for Kirk Tousaw, none of us would be even in this room right now. So give it up for Kirk Tousaw.
Thanks, Alex, very much, and thanks to the ICBC for putting on this incredible conference. It's been a great 2 days. I hope everybody's enjoying themselves as much as we are. I'm going to just give you the format of what we're going to do here today. I'm going to give a little bit of an introduction of these two fine gentlemen to my right, give an overview of Canada's current medical cannabis regulatory policies. I'm going to pose a couple of questions to these very smart individuals. They're hopefully going to make me look good with their answers. And then we're going to kind of turn it into just a discussion. We're hoping to have a lot of participation from the audience. I think, if you've got a question about the medical regime, the transition towards legalization, it's probably shared by everyone in the room. And we'll do our best to sort of dust off our crystal balls and prognosticate a bit and try to talk about how things are right now and where things might be going as we move this policy, this industry, and this culture forward here in Canada. So to my right, joined on the panel here is Rob Laurie. He's the principal of Ad Lucem Law Corporation based in Vancouver. He attended UBC and Oxford University. He was called to the bar in the United Kingdom in 2006 and the province of British Columbia in 2011. Rob's doing a ton of work right now, working with dispensaries and others in the cannabis industry here in Vancouver and really across the province. And it's a real pleasure to have him on the stage with us right now. Immediately to Rob's right is a man who probably needs no introduction. He's the godfather of ganja litigation. without John Conroy, Rob and I would be not doing what we're doing, and certainly not doing it anywhere near as successfully. It's John Conroy, QC, Conroy Law, and really his list of accomplishments in prison law reform, and fighting for human rights, and fighting for people's rights, and being founder of Normal Canada back in 1971. There's not much you can say. My mentor, one of the best lawyers I've ever known, one of the best people I've ever known, that's John Conroy.
Thank you. Thank you.
There we go. So let's kick this off with a sort of where we are right now. As a result of litigation brought by John and a team of lawyers back in 2013, 2014, when the Government of Canada moved away from the medical marijuana access regulations, a medical cannabis exemption scheme that had as its primary focus personal and caregiver designated production for a limited number of patients. A lawsuit was filed called Laurie versus Canada because the Government of Canada chose to transition away from that system and towards a commercially oriented system called the ACMPR, marijuana for medical purposes regulations. That system took away home and personal and caregiver production rights entirely from all patients, and it forced you instead to access your cannabis from a group of then non-existing but now existing licensed producers who have managed to navigate a very top-heavy bureaucracy and obtain licenses to produce and sell cannabis to medical patients. I think it's fair to say that that system has not worked very well up to this point. I don't think we necessarily need to belabor that right now. But that lawsuit triggered success earlier this year. The MMPR was struck down in their entirety as being unconstitutional in February of this year. The court, in a very, I thought, well thought out and strong opinion, eviscerated the Crown witnesses who suggested that there was some sort of intrinsic danger in producing cannabis and you'd destroy your homes and burn your neighborhoods down and do all these terrible things. That was, because it's not true, not believed by the court. And so the court gave the government 6 months to fix the access problems existing with the MMPR. And so what the government did is brought in this new acronym, this new regulatory scheme in August of this year called the ACMPR. So we're really in the infancy of this new program. And the ACMPR, the Access to Cannabis for Medical Purposes regulations, promulgated under the Controlled Drugs and Substances Act, essentially did a couple of things. They breathed new life into the commercial production aspects of the MMPR. That was sort of brought back. The licensed producer system remains in place. It has not been significantly streamlined as of yet. There continue to be hundreds of applications in the pipeline that aren't really moving at the pace that are necessary. It's also very difficult to navigate. And they sort of mushed that together with the old MMAR. And in effect, the ACMPR and the old MMAR are pretty much the same. They feature pretty much the same process for getting, it's no longer called a license, now it's called a registration. I'll probably call it a license many times during the course of this talk, but it's basically the same. Allopathic physician signs a medical document, sets out your dosage, you submit that to the government, you can then register yourself as a personal producer of a number of plants that are calculated based on that dosage at roughly 5 plants per gram per day for indoor production or 2 plants per gram per day for outdoor production. Or you can designate someone to produce for you on your behalf. They become the grower and they can then, and they can charge you. They can provide the medicine to you. Designated producers can service at most a maximum of 2 patients. That's a feature of the old system that was preserved in the new system. I think it's unconstitutional, and we can maybe get into that later. And you can have a total of 4 production licenses or registrations at any one physical site. Again, that's a holdover from the old system. There are a number of tweaks and features to the ACMPR, but in sort of broad brush strokes, that's what we have. We have the MMPR and the MMAR mushed together, and you have one system for commercial producers and one system for home and or designated producers. The injunction that was granted that preserved MMAR rights for about 28,000 patients continues to have vitality today. If you were protected then, you're still protected now. Government's going to have to go back to court to try to undo that injunction, and they may do that at some point in the future. If, however, anything needed to change from that status quo as of at the end of 2013, early 2014, you need to now go through the ACMPR to move your licenses, to grow at a different location, to increase your dosages, to change your designated producer. Any changes to the status quo at the time of the injunction require you to be the new participant in the new system. So that's the broad brushstrokes overview. I'm going to kick this off by asking Rob a question. And that's, if in his review of the new ACMPR, are there pressure points and issues that he's identified that could be problematic in that regime as we move forward?
All right. Thank you, Kirk. And let me just start off by saying it's a real honor to be up on a panel with these two and to be part of this great conference. So give yourself a round of applause for coming here. All right, so pitfalls, limitations and problems with the ACMPR. Now, to start out with, this ACMPR was really, it's designed to salvage two medical programs that have been in place for a while. The difficulty is as Kirk mentioned in the panel this morning, doctors have been forced with the role of gatekeepers. And so under the ACMPR, you still have to go to a doctor to get what would be known as a prescription usually. And the problem is those doctors are not signing those as readily as we would like to see. So that's one issue. Even though if you do get a permit under the ACMPR to grow cannabis, well, it's not like you can pop down to Crop King Seeds or, Mark Emery's or wherever. You have to buy your seeds from limited supply and limited sources. So in my opinion, that doesn't really seem like a free and fair market. Again, limited strains. The licensed producers, in many respects, are limited with what they can supply the patient market with respect to what Health Canada says they can. So really, unless you fit within those very limited exceptions, you have a problem. Even if you do get your prescription or recommendation to grow, well, what do you do for the 3 to 6 months of your first cycle, right? So again, that's why we're seeing dispensaries, unfortunately, or fortunately, however you want to see it, are really going to remain the reasonable, dignified patient access. And let me just see the other pitfall. I'll give you a story. My dad was recently diagnosed with cancer, and if I had followed the law and waited for him to get a doctor's prescription and so on and so forth, his stage 1 rectal cancer would have spread. In fact, I gave him an address of a farm in Mission, and he's been on the suppository. So I guess it illustrates the problem of, do I follow the law or do I help my dad? And I can assure you I'm going to help my dad. And I know the majority of the folks out there that are requiring access to cannabis can't get it without feeling like they're in a position where they're breaking the law. And I think that's the biggest issue that this legalization question has to address. So those are my thoughts on the limitation and pitfalls. Well, what do you think, Kirk?
I think Rob identified 6 points. One was the doctor's gatekeeper. The second one was the limited sources for starting genetics. Third is limited strains available in the LP system. Fourth is access for home producers or designated producers during in-between cycles or downtimes or crop failures. The fifth is that dispensaries are now part of the legal regime,
That's right.
And yet they're the primary access point for most patients in Canada. And then 6 is related to that, and there's a limited range of products available in the lawful regime. So, John, hearing these problems identified with the ACMPR, what are your thoughts on, as we transition towards legalization, how some of these different points can be addressed?
Well, my hope is that many people will apply under the ACMPR, whether they like it or not, if for no other reason than to tell us what problems they're having with it. Because remember, Allard, the injunction continues until the court orders otherwise, or until further order of the court. So those people who were fortunate to be grandfathered by the injunction are protected by the injunction. situation, but they don't lose that status if they applied under the ACMPR. And you've got all of the people who weren't, who were called the left-outs, or who weren't covered by the Allard injunction, who now can finally apply to get their licenses again and at the locations that they want to, because one of the biggest problems was trying to change your location. And so you have to, though, remember that this was a temporary solution that was forced on the government by the order in Allard. They had 6 months to come up with something to fix the defects in the MMPR. And also remember that the evidence in Allard pointed to the defects in the MMPR, which led to the patients voting with their feet and going to the dispensaries, which led to the surge in dispensaries, which leads to the argument that really the dispensaries are lawful, in that they're simply filling the void that was created by the MMPR. So it's still a temporary solution. We need to know what the problems are that people are having with it, because there are going to be more changes. The Task Force on Legalization, there's a whole part of their mandate that deals with medical. And so my view is, as we move towards legalization, hopefully, it seems very difficult to get some people to overcome this attitude that they have to cannabis and marijuana. But hopefully they'll realize that they no longer need all this security. They no longer need all of these limitations and restrictions that they've imposed simply because of this somewhat ridiculous fear that it's all going to go into the illicit market. And there's, you know, the idea, in my view, is to flood the market so that there's lots of cannabis around and there's no longer any interest or profit to be made as far as organized crime, which they always throw up as being the people who are out there trying to make a profit out of it. So, you know, hopefully we will transition into a situation where, as is apparently happening now in California, they're trying to ensure that the small producers are protected and are able to participate in the market, not just big producers, so that all of the people who've learned how to do it well and produce good strains will be able to continue and to participate on a fair basis with others, that the dispensaries will continue to exist in terms of the medical, but as a distinct, perhaps a group compared to stores that will be able to provide legal access to people for social purposes. And so my hope, and it is a hope, but I'm not, I've been around and have been involved in this for so long that I am somewhat cynical as to what will happen once the task force hands this over to the politicians, even though the politicians are saying they will legalize. What form that takes is of significant concern. But hopefully they will come to their senses and realize that there's an existing market with existing suppliers, with existing distributors, with existing stores, and they will try to simply regulate them in a fair way, as opposed to trying to change it by squeezing this or squeezing that. They're just going to create more problems and more litigation. So, as I say, they've created the, as Kirk points out, part 1 of the ACMPR is the old MMPR, part 2 is the old MMAR with a few tweaks. It's essentially the same, but because of the abuses by doctors in particular, the colleges across the country and the Canadian Medical Association and provincial associations have clamped down on the doctors. And this has created a problem for those doctors that did have a positive attitude or knew something about cannabis. And they're all fearful that they're going to be hauled up in front of the colleges and stuff. When really, it's the doctors who are charging huge fees and who were, you know, having people just line up and signing for them without bothering to do anything as far as their medical situation is concerned. Or I heard even charging on a per plant basis was the last one that I heard. So you can understand why the colleges have come in, because they see some of their members clearly just in a total conflict of interest, just doing it in order to make money, nothing to do with the medical situation. And so the doctor gatekeeper thing I see as the looming problem, which is not a problem necessarily of the ACMPR. It is to the extent that we've always said doctors of traditional Chinese medicine, naturopaths, people who know something about real whole plant medicine should be involved, not just allopathic medicine types who are used to prescribing a pill and take 2 of these and mail in the $5 type of thing. So, that certainly is a tweak that could be, I think, part of a criticism of the ACMPR. But the bigger problem is how to get these colleges to come to their senses and to get up to date in terms of the information that's out there about cannabis and its uses for medical purposes in particular. And so, we had the Murnaugh case some years ago, which unfortunately didn't get through due to a lack of evidence on some of the areas. So we really need to document the problems people are having, because Allard is until further order of the court. And so at some point in time, whether it's us or whether it's the government, we'll be back in court. And we need to know and have evidence to show the court what the problems continue to be, so that the court will hopefully not just say, okay, the ACMPR is the solution, what are you complaining about, it's all over. So that's why I've been saying, fine if you're protected, great, but if you're not protected, both protected and unprotected should apply, so we can see what the problems are and document them, and then we can at least have that body of evidence to produce to Justice Phelan when we do have to get back into court. I certainly hope that the government legalization model will undo huge numbers of these restrictions. But I'm troubled when I hear the chairperson, the other day I was quoted as saying that young people shouldn't smoke anything because it causes cancer, which then I said to myself, well, you obviously haven't kept up to date in terms of what the smoking of cannabis and the difference between smoking cannabis and cigarettes, and that there is no evidence of cancer. In fact, the opposite, that there isn't emphysema, that it is a bronchodilator, these sorts of things, and that some patients need to smoke it because they need rapid onset. Eating it and waiting an hour isn't going to work for them. So, getting them to understand exactly how it works. I mean, I shake my head because I've been involved in it since the early 70s. People were being sent to jail for simple possession in those days. And, so from where I sit, things look way better than they used to. But we still have these ongoing issues and problems which astound me that they continue to some people to have this sort of attitude. But the fight isn't over. We still have obviously some looming issues to come. And again, I think, our experience with the task force, those of us who appeared in front of it, was very good in terms of being able to provide them with information, and the information seemed to be very well received in terms of all sorts of areas. But again, even if they come up with a good model, we have seen even this government have committees, not follow the recommendations of the committees, not follow the recommendations of their independent Senate. So I have to say, it's a wait and see, A, as to what they recommend, and B, then what the politicians do with it afterwards.
All right.
So I think we're going to turn it over to the audience and see if we can get some questions, if anybody has anything they want to talk about.
Is over here.
Got a hand over here.
She's running away. In the front down here.
We'll take this guy here first.
Thank you guys for coming here and talking today. I just wanted to know what kind of legal consequences could you expect for an unlicensed grower arrested for cultivation if that grower can prove the cannabis was being sold for medical purposes in a licensed dispensary?
Yeah, so that's a sentencing law question. I could throw something out there, and John will tell me where I get it wrong, perhaps. But where are you? The number one question is, where are you? Because sentencing tends to be different in different provinces. All right, so you're in British Columbia. So there's a fairly long line of sentencing authority in British Columbia imposing very lenient sentences for producing cannabis for medical purposes, even if contrary to existing licensing or outside the licensing scheme. Now, a lot of that case law imposed what's called a discharge, which is a finding of guilt but no entry of criminal conviction. That's obviously a pretty good result if you get to that point. The difficulty is that the Conservative government's changes to the Controlled Drugs and Substances Act, increasing the maximum penalty for production from 7 years to 14 years, and imposing mandatory sentencing in some cases, means that production as an offense is no longer discharge eligible. So you cannot receive that outcome of guilt but no entry of criminal conviction. If you're found guilty, you will be convicted. You will have a criminal conviction entered against you, and the penalty is going to range from, at the low end, perhaps a suspended sentence or a fine or some kind of probationary disposition, to, at the higher end, potential mandatory minimum sentencing legislation based on the number of plants and the presence or the absence of any aggravating factors. Those laws, those sentencing laws, have been from time to time found to be unconstitutional, and so it remains to be seen whether they would have any continued vitality going forward, but they still are on the books, and I don't believe the litigation's progressed to the point where you could say with confidence that they would not necessarily apply to you. And those tend to kick in after 6 plants, between 6 and 200 if grown for the purpose of trafficking. Between 200 and 500, there's another range of penalties, and over 500, there's yet another range of potential mandatory minimum sentences. John?
It used to be that what prejudiced you in life was getting a conviction. And I've written a paper on the prejudicial consequences of a non-conviction in Canada, where people get stays of proceedings because the Crown suddenly drops the charge. And everybody's happy thinking, oh, the charge has been dropped. But you'll still have problems at the border with a stay. You'll have problems in other places with a stay. Another thing they do is withdraw the charge. But this digital age, I'm afraid, has created a situation where whatever's in the digital database somewhere, oh, you were seen in a car with somebody who had a joint, your passenger had a joint 10 years ago. And a guy like Corporal Holmquist, who was the main witness in Allard, who I just spent the last week arguing about again in another case, he's the guy who goes to these databases and digs it up and causes these problems. So we've got convictions and sentences, and Kirk referred to the discharges. It was the current Prime Minister's father, Pierre Trudeau, who introduced absolute and conditional discharges because of cannabis offenses, so to try and reduce the consequences for people of having a record. And you should know that even if you get an absolute discharge, the record remains for a year before they have to take it off, and a conditional discharge, it remains for 3 years. And then in more recent times, because we've always complained about the over-incarceration of people in the country, the government brought in conditional sentence orders. And a conditional sentence is quite distinct from a conditional discharge. It is sort of the last step before actually being sent to prison. And so you could have a conditional sentence where you served your sentence at home or at least in the community subject to various conditions. Before conditional sentence orders existed, we used to be able to get people probation and a period of maybe a couple of months of house arrest so they could still work, support their families, and so on and so forth, even though there was a sanction. So I just argued a case maybe 6 months ago now called Neary in Saskatchewan, where we argued that now, with the government having said it's going to legalize, so what is the Crown supposed to do? What is the defense supposed to do? What's the judge supposed to do in sentencing? The principles of sentencing that one looks at, a major one is to denounce the conduct. And so we said to the judge in Saskatchewan, well, the government here is on one hand saying, give this guy 15 to 19 months. It was a trafficking, possession for the purpose of trafficking case, about 30 pounds. And on the other hand, the government's saying, we're going to legalize. So, denounce conduct that you say you're going to legalize. Another sentencing principle is to deter others who are like-minded. again, you know, you're going to legalize, so people are going to do it. So, you know, what's going on here? I mean, the other ones are you reformed and rehabilitated? Well, usually it's a year later, and the person has usually managed to do all sorts of things to appear at least to be reformed and rehabilitated. And the other one is specific deterrence. So we said, look, you know, Judge, the Crown here wants 15 to 19 months, and they've taken away, the Conservatives took away the ability to impose conditional sentence orders, and here was a classic fellow who would have got a conditional sentence order if they still existed and didn't need to be sent actually into prison. And to my surprise, the judge accepted our argument, and he said, we are in an interregnum period between kings, between governments. And he gave him probation with a couple of months of house arrest and some other ancillary orders, you know, firearms, etc., etc. And the government has appealed that, so they run the risk of the Saskatchewan Court of Appeal hopefully accepting the position. I just heard the other day they want us to be there November 10th, but I think it's more likely to be at the end of November. But I also heard other counsel have succeeded in a dial-a-dope case to get a conditional discharge for somebody based on Laurie. What was it? Jordan? Yeah, Jordan. Maybe it was, yeah.
That's the delay case.
No, that's been from Canada. This is a recent sentencing in British Columbia. So we're encouraging other lawyers and certainly people who are facing these sorts of issues to get their lawyers to make that same argument and rely on Laurie to point out this problem. And you criticize some of the Crown Counsel. I've known some of the people in the Federal Department of Justice for a long period of time, and they're quite candid, some of them with me, not all of them, but some of them, about how they're in this awkward position. You know, what are we supposed to do? We're sort of getting conflicting positions here in terms of what we're supposed to do. And of course, as Kirk mentioned, mandatory minimums. It's ridiculous that they've brought in these mandatory minimums, and it's ridiculous that this government hasn't moved to get rid of them. You know, that should have happened by now. And yet we're still forced into situations where we have to make these arguments. I've got a guy next week who, he was a guy who went and watered plants to make a little extra money. He wasn't involved in any other aspects of this grow operation. He wasn't benefiting in any other way from it other than being paid. And he's the only one charged because they screwed up in relation to the main people and all the rest of it. And they're wanting 3 years mandatory minimum for this fellow. And so you say, you know, okay, so we're going to have another challenge to the mandatory minimum. We're going to have another challenge to the fact that they took away the conditional sentence orders. And it's going to wind its way, these cases are going to wind their way up through the courts. And come the spring, they're supposed to legalize or start the process. So what are the judges supposed to do? You know, they're sitting there saying, wait a minute, you know, this doesn't make sense. So there's a real problem, and we really need to somehow get the current federal Liberal government to move quicker or move faster and get this sorted out so that we can put this behind us and move forward.
You better take some more questions.
Yeah, let's hear from another.
Okay, first of all, I'd like to agree with your point that doctors are an issue. Doctors are not available in a lot of the province. I mean, people don't have doctors. They can't get access to a doctor. I mean, many people can. So it's really an issue. I mean, in Vancouver, there's lots of doctors, but out in the country, it's hard. Okay, they're just simply not available. So that's a real barrier. Okay. And secondly, you know, the licensed producers in the old MMAR regime, they're getting forced out because they can't afford the access barriers now that are in place, okay? So we're changing the whole base of the industry into these great big players that are squishing out the little guys that actually formed the industry and have been on the front lines fighting all the way, okay? So it's really not right. And secondly, I'd just like to point out, I finally did get access to a temporary doctor. I managed to I applied for and got my medical grow. Okay. And you were mentioning, and I also saw on the website that it's supposed to be 2 plants per gram?
An outdoor license is approximately 2 plants per gram per day.
Right, well, they're issuing under the old amount still. So I got issued 1 plant per gram outside and 3.7 for inside, so.
Oh, you went with a split license, indoor-outdoor.
Yeah.
Right.
So there is a different formula for, there is an indoor-outdoor license, you can only grow indoors or outdoors at any
Right.
one time, but the formula is different if you apply for that licensing, because the assumption is that you're gonna grow indoors during the indoor cycle and outdoors during the outdoor cycle, and they sort of think you'll produce X amount of cannabis as a result of those 3 cycles a year.
And that's one of the things that's carried forward in the ACMPR. You can only grow indoors or outdoors. And does that make sense? I mean, I would think people would start indoors, try to get them outdoors when you get some good weather to reduce your hydro costs, and bring them back in before the mold sets in, you know? Certainly bring them lower end.
So there continue to be these issues. There's no doubt the ACM, and to be fair, you can't, no regulatory scheme is going to capture every potential factual situation, but that's why the scheme ought to have some more flexibility than that. And at the end of the day, any plant number is pretty arbitrary, isn't it? What does it matter? I mean, why should you have to grow 4 big plants instead of 40 really small plants? Maybe that's your preferred growing method. At the end of the day, the question ought to be, are you growing that for commercial purposes, in which case there's a different system for you to be part of, or are you growing it for yourself or provision to caregiver? Then it's a ball ballgame entirely.
What most people overlook is, because it's been a criminal issue, but now we're looking at product liability. When I hear for the old MMAR growers that say, but I had a right to grow and like sell it to people under MMAR, it's like, no you didn't. You had the ability to grow for yourself and grow for someone else, and that's it. But when you then give that product or sell that product in a commercial retail-like setting, there's a whole bunch of other rules. I mean, for any of the lawyers in the room, you only have to look at Donahue and Stevenson, which was a case of a snail in a bottle of ginger beer in England about 100 years ago, which essentially means that you have a duty of care that is owed to the ultimate consumer. So if you're selling or producing a product, and then that goes to the dispensary, and then the dispensary sells it on to somebody, well, you then have to ensure that product, and you meet the duty of care to the ultimate consumer. And so really, until we figure out definitively how are we going to get cannabis by the mail, dispensary, liquor store, that's really going to determine a lot on that.
Do we have another question?
Yeah. Go with Neil.
Hey, I think we need a few good lawyers by the sounds of it. Who are these people? Are we not free? I mean, who gets to tell you how many plants you can have, and why is cannabis treated more harshly than tomatoes or potatoes and all that stuff? We've actually known for a long time that they're full of shit, that they lied their teeth about this, that cannabis was never a dangerous drug. It was only ever a threat to corporations and people who wanted to sell you their stuff. And so the whole thing is a huge scam, and it's a huge crime against us, and it's continuing, and there should be some repercussions for these people. They shouldn't be able to just get into the business of now selling us weed after they spent their lives penalizing people for it. We need some lawyers to go after these people. They should be held to the fire. It's a huge, huge crime that's happening.
You're obviously preaching the choir at this conference.
Yeah.
And we're all cannabis
We can't
enthusiasts.
keep up with you, Neil.
I would say on the question of, should lawyers go after people that are legislators that then get into the cannabis industry? I mean, in law you have to have causes of action. You have to have bases for lawsuits. You can't just sue people because you think they're bad people or did bad things.
They've hurt a lot of people, and they've known for a long
but
time.
in law you need a cause of action to sue someone, and it is not, to my knowledge, a cause of action to be wrong in legislative policy.
No.
Change your mind, vote for something new, and then later become part of that industry. That's not a cause of action, that's just what happens.
No, I'm not saying prosecute for the ones getting into the cannabis industry. I'm saying the ones that maintain these prohibitions, knowing that they were wrong and in violation of free people and hurting people, that's a huge, huge crime.
Neil, you
I
always
agree that it's politically unwise, morally reprehensible, but I don't see a legal cause of action. that would
How do you
foundate
stop
the
people
basis of
supporting
the lawsuit.
Donald Trump?
That's a
selective, that'll teach him.
Well, I mean, your power comes in the ballot box. That's where you exercise power over political officials, at the ballot box.
They get away with it.
Yeah.
We have another question.
Next question.
My quick answer to you is, I think education, how we help
Yes.
Donald Trump supporters
There
through
you go.
education, I think will make some better decisions. But I have two questions,
Well,
completely
good point.
unrelated, but maybe sort of related.
Okay.
My first question is just voicing more of what Jody was asking yesterday. What is going to happen to the people who have already been wrongfully incarcerated for using cannabis, simple possession, once legalization comes about? Are those people going to be remaining in jail? What's going to happen with their process? My second question is actually just more to what you were mentioning. A lot of people in rural communities don't have access to doctors that are on board, that choose not to educate themselves, and I know that that's very frustrating. I'm wondering, isn't that doing harm by choosing to remain ignorant to something that has a lot
Hit
of...
the nail right on the head.
Well, really, but it's philosophical, but it's also legal. So those are my two questions.
Sure, why don't we, John, you've had many more clients wrongfully incarcerated than I have.
John is actually an expert on prison reforms. That's a great question.
He is. He's an expert on prison policy, been fighting for the rights of prisoners just as long as the rights of cannabis consumers. So what does happen?
It was a stepping stone to lead.
What can and does happen when we legalize cannabis to all the victims?
Well, you know, my hope and expectation would be that we will have a government commuting and providing amnesty or, you know, remission, these sorts of things. We do have a process for getting royal prerogatives of mercy and pardons and these sorts of things. So I would expect that there will be some movement to try and decarcerate people who are in that situation. I mean, my position is broader than just cannabis. I don't think that drug use of any kind should be subjected to the criminal law. It's a health issue.
Yeah.
And, trying to control people's use and providing a black market for organized crime, essentially. It's just absolutely stupid.
Yeah.
But in terms of your other question, I mean, I think, again, the digital age hopefully will enable people by Skype and other sorts of ways to be able to access doctors remotely in order to deal with that problem. I know that some doctors are doing that. Again, the college sometimes raises issues with them doing that if they're in different provinces and things like that. But surely that's the obvious solution is if you're in a remote community and you don't have a doctor and you're entitled to reasonable access, the doctors who understand the issue and who are supportive you should be able to access them online and do that.
Can you take legal action though against those doctors who choose not to educate themselves?
Or the college?
I was going to throw that to Rob. Is there, in your view, a cause of action against an individual doctor or a college for its prescribing or prescription-type policies or refusals to assist patients?
Well, there's definitely a cause of action. The question is finding a cause of action that the courts will take serious. Now, one of the big difficulties is when you go up against a regulator, which has had authority delegated or power delegated to them by the government. There's an expectation that, well, the government entrusted the college with power to essentially make mistakes. I mean, their job is to try to regulate policy the best as they can, and although, like, I'll be devil's advocate, they may not get it right all the time, they get it right sometime. And unfortunately, that's really how things evolve and get better. I think the answer that you need to be looking at is instead of like, well, I need to deal with the college, I need to, you know, fight all these battles. I think the better way to look at it is, you know, did women wait around to get the vote? No, they engaged in civil disobedience until the laws and the rules changed. What's so fascinating about, you know, we saw in Allard, they didn't really address the issue of dispensaries, but despite the intense enforcement in Ontario and the lack of enforcement in British Columbia creates this patchwork quote scenario, where the difficulty I see it, I mean, we had Brendan Kennedy this morning, and it's all very impressive, but this is a race to the bottom, ladies and gentlemen. Folks have been growing and engaging in cannabis. I mean, some of our clients have been doing this for 40 years, and I'm confident tomorrow they're going to wake up and continue to do what they're doing regardless, right? And so really, these are who the corporate, and I have a Wall Street background. I worked in London, City of London, and New York with the CIA's law firm on Wall Street. And all of this really is, ladies and gentlemen, is designed to be a mousetrap to essentially work for the people that lobbied and put policy for the system. So every day that you go to a dispensary and make that decision to shop there, or to inform yourself and educate yourself and make the decision that if cannabis is right for you, that's a decision that you need to make. And so you can wait for the government to get it right. And actually, I'll use an analogy, as they say in Texas. You can wish in one hand, shit in the other, and see what fills up first. So I think the question is the government may or may not get it right? Well, show them how they should do it. And so that's where I think the future really is civil disobedience and social engagement, because it's the communities that are making the changes, and the monies are flowing up the grassroots back into the community, not to Ottawa.
Let me just speak to the issue you said in terms of the doctors and the colleges. I mean, again, the colleges are doing the right thing, in my view, in trying to clamp down on the doctors that are abusing the system. But it's having this impact in affecting reasonable access. And so I think in the short term, we need to get the doctors, there is a group, the practitioners for cannabis medicine, I think it's, if I'm getting the name right, that is a group of doctors across Canada who are fully supportive and knowledgeable about cannabis. These folks have to be the ones going after the heads of their colleges and being the ones to try and bring them, educate them and so on. Just like we lawyers, if it's the Law Society or the Canadian Bar, we need to be the ones who go there to do it, rather than just thinking you can start a court case and somehow that will sort the problem out. Let me just, for a quick story for you though, because Rob mentioned women and the right to vote. You got to remember that it was one of the famous five who wrote the Black Candle, and it was the Black Candle that was serialized in Maclean's magazine across Canada, that was based on all the stories in the U.S. that led to 1923 cannabis being put in the Schedule to the then Opium Narcotic Act, following on what we did here in Vancouver when we had all the Chinese who came and built the railroads and were our best workers, and many of them were killed doing so, and we had opium dens. They brought the opium with them from China after the Opium Wars and so on. We had opium dens all over Vancouver, Victoria, and New Westminster, more than the dispensaries. And it was a labor situation that led to them shutting them down and kicking them out. You go to the Dominion annual statistics, you'll see Chinamen deported possession of opium product. And so when you look into the history of drug prohibition, it all goes back to that. The Chinese in terms of opium, the black people in terms of cocaine, it was the Mexicans in terms of cannabis, starting in, I think, Utah with the Mormons and then spreading across the United States. So, these sorts of things still happen where people say we're losing our jobs, they blame people of color, and these sorts of situations develop. So we have to try and all rise above these sorts of things and try to educate people in terms of what's reasonable.
If I can make an observation before we get to another question. A lot of people say, well, what's going to happen? What's going to happen? And, well, let's look at another simple example in Vancouver. So history repeats itself. The Penthouse nightclub and the Commodore Ballroom got their licenses in 1969 and 1971 respectively. So what was happening during the 40s, the 50s, the 60s, and then early 70s? Well, they remained open, and I think really the key is if you survive and stay open, you will in 20, 30 years get a history commemoration plaque from the provincial government. So I think really, just think of the words of Fidel Castro, condemna me no importante, la historia me absolverá. Condemn me, it's not important, history will absolve me. And I think that's what's going to happen in this market.
So I think we have time for maybe 2 more questions.
1 year, that might be about it, but I'm sure they'd love to talk to you more in the hallway.
I got a question here. I wanted to ask you, people keep telling us, oh, it's going to be legal in the spring. You're just impatient once it's legalized in the spring. I don't feel it's going to be legal in the spring, and I would expect people to still be charged for possession all through 2017. I'm curious as to what you feel about the timeline for the federal, provincial, and municipal legalization. If you think I'm right, there'll still be possession arrests and enforcement all of next year. And what you should anticipate as the timeline over the next year or two, and when we're actually going to be able to buy some kind of government-approved cannabis with Justin Trudeau's stamp on it in a store at some point, or if that's ever going to happen.
So I think we may have different views on this. I gave my view earlier today in an earlier panel. I'll just repeat that briefly, and then I'll flip it over to these other gentlemen to sort of look into their murky crystal balls. But you know, the timeline that we know is that next month the task force is going to make its recommendation to Bill Blair. Bill Blair will then regurgitate and that up to his bosses, ministers of justice, health, and public safety, with his own commentary added into it. They've told us that that's the timeline. The government has promised to introduce legislation in the spring of 2017. Spring session of Parliament lasts about mid-June 2017. I would expect if legislation is introduced at first reading in the spring 2017, we don't get through third reading in that spring session. So I expect the whole thing's over until the fall session of 2017. I expect there will be extensive committee hearings because despite the fact that the government has said it's not about whether we're going to do it, it's how we're going to do it. They know the eyes of the world are upon Canada. They've said that repeatedly. Everybody's going to want to have their piece of the action and a piece of the publicity in Ottawa. So, you know, I think that could drag on through the remainder of 2017. Then the bill goes to the Senate for review. They do committee hearings. They look at it some more. And then it goes back to the House. And if it goes back changed, the House has to sort of then either adopt those changes or try to override them. You know, my own guess is that we don't have legislative change until early 2018. That legislative change is also going to require each province and territory in this country to participate and to have a distribution plan ready, because the feds have signaled they're going to retain jurisdiction over manufactured production. The provinces are going to deal, and territories are going to deal with the distribution piece. So, you know, I think we're a long ways out from buying legal cannabis in a store, whatever that store might look like. And you're right, I mean, the tragedy of this all is that people continue to be arrested for violating these laws, and I gotta tell you, it doesn't have to be that way. The Public Prosecution Service of Canada, before filing charges against individuals in British Columbia, have to determine whether filing those charges is in the public interest and whether there's a substantial likelihood of conviction, not discharge, conviction if you file the charges. You could stop prosecuting simple possession offenses in this country as a matter of policy and prosecutorial discretion today. And the reason it hasn't happened is because the political pressure has not yet been applied sufficient to make them, the Liberals, believe that this is a vote loser in the next election. And they're probably right about that at the current calculation. But I think pressure will continue to build because the judges, as John's recounted to you, when you put in front of a judge the idea that you've got to sentence somebody for simple possession or even for growing or trafficking cannabis when we're making it legal, the judges are scratching their heads and saying, what are we doing here? And at some point it may get taken out of the hands of the government, by the courts, and there's a fear there.
I don't disagree with Kirk in terms of the timeline. I think, the spring they're supposed to introduce legislation and we'll see what happens. We have a similar problem to the U.S. where the U.S., you can have a government that takes a position, but you've got a Congress that's stacked with still Republicans. Here we have a Senate that still has more conservatives. So, that needs to be fixed in order to make sure everything goes through. My experience with, as I said, when I started, people busted for very small amounts were getting 30 days in jail and things like that. And throughout the 70s and 80s and so on, I've seen that reduce and reduce and reduce, and to, you know, it used to be a $100 fine was very common, and then discharges. I do not get people charged with possession anymore. I haven't had a possession case for ages, other than sometimes a large amount that in the past they would always charge possession for the purpose of trafficking. Now is simple possession. So I think, and I'm talking Abbotsford police, who aren't known for necessarily them being very progressive in this area, at least in the past, and even RCMP, who are known to be, or were thought to be less progressive, although I see them coming around quite a bit as well. And so that's pretty key, but we still are always going to run into that problem of they'll use the smell in order to get into your car to find out what else you've got, or to arrest you simply to then, you know, hassle you a bit before they then drop the charge. And again, my concern is that you're in a database. The minute that happens, you're in the database, and there's some further information that can prejudice you in the future. So, you know, hopefully we will at least see a big movement in the simple possession area. But what really needs to be addressed is, as Kirk said, the distribution and so on. You need to remember that at the moment, the federal government has the constitutional power under its criminal law power. And the Controlled Drugs and Substances Act is a criminal law statute, okay? And so if they take it out of the Controlled Drugs and Substances Act, out of the schedule, then they're no longer using the criminal law power. So what is the power? It's health. And that's a divided field between the provinces and the federal government, as Kirk said. So you need the provinces to get involved as well, and they've been not jumping in at all.
I know in Seattle, Washington, the district attorney there made it part of his platform when he ran that he was not going to prosecute simple marijuana possession cases. He told the cops that, and arrest dropped. This is before the initiative passed to legalize marijuana. And then to the other point about the two-part point, that's what Oregon did. They legalized possession first, and then came up with regulations in order to get the ball rolling. I think we have time for two more. One more. I know you had your hand up the whole
Gotta be
time.
quick, I think it's 3:30, so
They
we
get very long.
gotta make way for Ed Rosenthal here, folks.
I've got a question for the panel. The MMA are individuals who are allowed to grow for themselves, friends and family. The MMPR allows these juggernauts to grow for multiple patients. Thanks to 2 Smiths and 1 Tousaw, the derivatives were allowed to be made by these juggernauts, and it seems that they are limited to 3% potency, which seems like a form of insanity to me. Under the the ACMPR, I'm told that individuals that used to be MMAR holders are now allowed to make derivatives. The legislation still states that you're allowed to collect 4 licenses to one property for growing. I've been told that you're allowed to collect the outdoor storage facility under multiple licenses, and perhaps that would be a good place for individuals to do extractions. Is there a limit on how many licenses can be in one storage facility? And is there a limit on the percentage value of the extraction made in those facilities?
Yeah, so in terms of patient making extractions or derivatives, they don't have any potency limits in place. You're not subject to the restrictions that the licensed producers are.
Except butane.
What you are restricted to is that you're unable to make any extractions using what the ACMPR defines as organic solvents. Organic solvents is then defined as butane, a couple other chemicals, and a catch-all is basically anything that can blow up. Now, you know, let's be clear, I think Smith overrides that restriction. I think that derivative makers that are doing it safely have very good defenses under the charter, that restriction that's imposed in the ACMPR is unconstitutional on its face. I've got a couple of cases currently of pretty big extract facilities that the Crown's making me offers you can't refuse on. You know, I don't think they want to litigate that issue in the medical arena right now. So, but the answer to the question of extracting is no organic solvents, otherwise no potency limits. you cannot your storage location under the ACMPR for a production license has to either be at the production site or at your ordinary place of residence.
Yeah.
So production site is artificially limited to 4 because you can only have 4 licenses at production site. I suppose if you had like 20 people all living together in the same house, there's no restriction that those 20 people could have their storage site at that one location. I mean, you know, but then doing extraction there, you know, the question would be, is the extraction, is the derivative making part of production, or is it part of possession?
Right.
And that's not defined by the ACMPR, so the locus of your derivative making hasn't been mandated. So, you know, I suppose theoretically you could aggregate a whole ton of people living under one roof and tons of storage there, and that would give you protection for a great deal of cannabis to be stored there.
Plus economies of scale.
But, you know, creative compliance is sort of my mantra, right? The government makes rules, lots of them are arbitrary and silly. Creatively comply with them, you know, as long as you're not breaking the rules, you're not engaged in unlawful conduct, and I think that, you know, we're creative people, so we can do it.
But remember, this is politics. And so every time you have an explosion and a fire and somebody gets hurt, it sets back the cause, okay? Every time you have people stinking out the neighborhood because they're not controlling the smell of their production, you set back the cause. I get constant complaints from inspectors at various municipalities. Conroy, there's a grow there and they're stinking out the neighborhood and we got all the neighbors complaining. So I have to get somebody in there to teach them how to do it without stinking out the neighborhood. We want the neighborhoods on our side come the spring. We don't want them against us. So politics.
Give it up one time. Right here. Let's bring up the beer. Thank you guys so much. Awesome. Give it up. Thank you guys so much. Yes, that's awesome. Yo, and thanks for making me look good. Thank you, Alex.
We saw you on stage last night. You look good,
Wow. You know, that's pretty much the bang for the buck right there. You know, if you want to know what's going on in Canada, these two guys. You 3 gentlemen, if I could ask you just to go outside because you will be mobbed at this turn of time. So, appreciate it. Thank you so much. Thank you guys so much. Yo, make some noise if you're having a good time, y'all. This has just been splendid. You're wonderful. We have an amazing special guest for you right now. He is the